And what I would say to you is, please listen to me till the end, and then by all means we'll talk about it. But I'm going to run through it, and if you guys can just listen to the end, and then we'll take questions. And Ed, I'm sure, might have a different viewpoint. I haven't gone through this with Ed. He has no idea what I'm going to say here. So here we go. A victory for freedom of speech. The Ricky Jones case and the power of context. UK legal system has handed down a decision that, while controversial, may ultimately serve as a significant win for freedom of speech. Labour councillor Ricky Jones, 58, was found not guilty of encouraging violent disorder following a case that has sparked widespread debate on social media and beyond. The evidence? A video showing Jones speaking at a protest where he appeared to suggest doing really severe things to far-right protesters. Yet, after a mere 30-minute deliberation, a jury acquitted him. Now, far from being a miscarriage of justice, this outcome highlights the importance of context in interpreting inflammatory words and the application of the reasonable person test. This is a cornerstone of UK law that protects free expression. Here's why I believe this is a good result, despite the outrage that it's provoked. The reasonable person test, a legal standard in the UK, asks whether a hypothetical reasonable individual would interpret and act upon certain words or actions. In Jones's case, the court, and more importantly, the jury, appears to have considered the circumstances surrounding his statements. Protests are often heated, emotional affairs, where strong language is not uncommon. And that applies to you sitting in your house. And it applied to Lucy sitting in her house when she was part of that. The video, while shocking to some, was delivered in a public setting with a clear political context. Yeah, it was. Opposition to far-right ideologies. There is no difference to having opposition to far-left ideologies either. No difference, right? The jury likely concluded that no reasonable person would take Jones's words as a literal call to violence, but rather as hyperbole or an expression of frustration. And this interpretation aligns with the principles outlined in the Human Rights Act 1998, which incorporates Article 10 of the European Convention on Human Rights, which guarantees limited freedom of expression. This decision contrasts with past cases where individuals have faced prosecution for inflammatory online posts. However, a critical distinction emerges there. Those convicted in similar situations, such as the 2024 cases, like Lucy, all pled guilty. And by doing so, they waived their chance to have a court assess the context or apply the reasonable person test. The court left with little choice imposed sentences. And now, yes, I fully agree that some of those sentences, and I strongly argue, were unduly harsh, given the lack of a full trial to explore intent or context. Jones, by contrast, pled not guilty. He allowed the judicial process to unfold, and ultimately it vindicated them. To date, and this is important, to date, no one who has pled not guilty in relation to this event, that's the 2024 riots, has been convicted. That suggests the courts are taking a measured approach to distinguishing between genuine threats and rhetorical excess. This outcome sets an important precedent. It reaffirms that freedom of speech, while not absolute in the UK, is robust enough to withstand provocative language when the intent and context do not support a reasonable expectation of violence. The 2013 Defamation Act and subsequent legal reforms emphasise balancing free speech with public safety, and Jones's acquittal demonstrates that courts are capable of making nuanced judgments. Ex-posts from users like Dave Barr and Maisie Daisy expressed disbelief and frustration, and some of you guys, I 100% understand it. with some suggesting corruption or inconsistency. However, the lack of convictions among not guilty pleas suggests a pattern of judicial restraint rather than bias. Critics might point to the Lamy Review 2017, which highlighted ethnic and racial disparities in sentencing, such as black defendants being 240% more likely to receive custodial sentences than white defendants. And while this raises valid concerns about systemic inequities, Jonesy's case does not appear to fit this pattern. His acquittal, regardless of his political affiliation, indicates that the court prioritised evidence and context over public pressure or political leanings. The harshness of guilty pleas for those who pleaded guilty in similar circumstances, and the sentences that were, in my view, imposed outrageously, have indeed been overly severe. Without a trial to assess intent or the reasonable person standard, the court had to rely on the admission of guilt, often leading to mandatory minimums or harsher penalties under the Crime and Disorder Act 1998. And this doesn't excuse those judges that I think went too far, possibly with government encouragement. I don't know if they did or not, but I think those cases were not properly dealt with by the judge. But to say the legal system failed them, that's not the case, because they never tested it. And this procedural difference underscores the key takeaway. Pleading guilty strips away the opportunity for a court to exercise discretion. Jones's case, by contrast, allowed for a full exploration of the facts, resulting in a verdict that protects both justice and free expression. Looking forward, the Ricky Jones verdict is not a free pass for inflammatory rhetoric. It's a reminder that context, intent, and the reasonable person test are critical safeguards in a free society. And while the video may have offended many, and yes, indeed it did, I acknowledge the discomfort it caused. The law must protect the right to speak provocatively, especially in the heat of political discourse, unless there is a clear evidence of incitement. Again, the absence of convictions among the not guilty pleas and at this event suggests the UK judiciary is striking a careful balance, and that's something to celebrate. Of course, this case will continue to fuel debate. Reform UK MP Nigel Farage's earlier call for Jones's arrest reflects a polarised views, where users like Benowine on X question how such words could go unpunished. Yet the legal system's response, rooted in evidence rather than emotion, offers hope that freedom of speech can and should and must endure, even in turbulent times. As John Milton argued in his 1644 work, Areopagita, the pursuit of truth requires the liberty to express controversial ideas. Today's ruling echoes that sentiment, and for that, it's a step in the right direction. What's your thoughts? Let me know.
Fundamentally, I agree with you. I don't think any of them should be in prison.
They shouldn't. No, they shouldn't.
I think that it highlights the issue of what pressure was put on all of those people like Lucy to plead guilty. What kind of legal representation did they get? What kind of conversations were had?
Yeah, there's no doubt in my mind, Ed, that she was pressured into taking a guilty plea. No doubt.
And to me, that's where as you've outlined, if the system is allowed to work, then it actually works well.
Yeah, and Johnny and John says it's a jury who provided the balance, not the court. The jury is the court. The jury is part of the court. It's part of the system. Therefore,
we need a klaxon for Nectaridus.
Oh, right. Thank you. Thank you, Nectaridus. You are, sir, a star. Oh, did you like? I hope you liked my soliloquy. Would it be fair to call it a soliloquy?
Yeah, no, that was good.
Yeah, I think she got. I think Dave Barnes is 100% right. She got dire legal advice, and yes, she did, because initially she pled not guilty. Remember, and she was remanded, and I was on Twitter and I was banging away saying she shouldn't be in jail because when she got refused bail, she did not meet any of the criteria for refusal of bail. So the court, the judicial system, wasn't working there. But if she'd continued to stick by her guns and plead not guilty and go to trial, she would not be locked up, because I think she would have got bail. I think they refused that bail just to go for it. I don't know. To be fair, David, I know Jonesy's team leaned on his neurodivergence, but I don't think that really matters. I think what's really important here is the fact that even anyone who's considered far right who pled not guilty hasn't been found guilty. And I think that's the important thing that we need to take away.